I am going to, in the next, half an hour, to take you quickly through several issues related to the EFTA Court. We will obviously be building on some of the issues you have seen earlier in the seminar. So my presentation will cover essentially three issues: legal framework of the EFTA Court, what I call milestones in the EFTA Court's case law, and finally the interpretation of EEA law. And with that, we will sort of also address the relationship between the EFTA Court and the Court of Justice. I'm happy to take questions at the end. I'm also very happy to take any questions you might have during the presentation. This, I'm sure, has been touched upon in what has already been said, but I wanted just to highlight a few issues which are important for what I intend to say and what I think are sort of key features of the EEA agreement. I have here in bold, in bullet point 1, the single most important word in EEA law, homogeneity, which I say here, same rules should apply in both pillars. So that's what it's all about. As we will come to later, the EEA is an extension of the internal market to the EFTA states, and the whole enterprise is about ensuring that the rules are the same, interpreted and applied in the same manner. So what is the EEA? I'm sure you've had that explained in some detail, and here is my sort of unscientific. I will get more to Sveinbjörnsdóttir in slightly more detail, but if you sort of strip away the legalese, it's a public international agreement with a twist. It's not quite how the EFTA Court phrased it in Sveinbjörnsdóttir, but that's the gist of it. So the EEA is not supranational, and yet it is. And I have put here that there was no transfer of sovereignty like in the EU, but there are some exceptions like in the field of competition law and some others, and there is neither direct effect nor primacy as found in the EU law. Of course, there are substitutes for that, which we might discuss. So after this very, very brief scene setting, I'll talk a little bit about sort of the setup and the framework of the EFTA Court. Just the EEA agreement, as Melpa was saying, provides for an obligation on the EFTA states to have in place their own surveillance system, so the EFTA Surveillance Authority and the EFTA Court of Justice, or the EFTA Court. And this obligation is discharged in the Surveillance and Court Agreement, by which both ESA and the Court are established, and Article 27 of that agreement establishes the EFTA Court. The further rules on the EFTA Court are provided for in Protocol 5 to the Surveillance and Court Agreement, which is the statute of the EFTA Court, sort of the basic rules, and then the Court itself sets out those rules in more detail in its rules of procedure, and new rules came into force now just over a month ago. There hadn't been a wholesale revision of the EFTA Court's rules of procedure since its start in 1994, so there was time to clarify them a little bit, and let's say a tidying up exercise. So these are the instruments governing the EFTA Court and its operations. Jurisdiction, very briefly, it's to rule on the interpretation of the EEA agreement. And when I say the EEA agreement in this sense, it's the main part of the agreement and all acts incorporated into protocols and annexes. So everything that is in it can be a subject of a ruling by the EFTA Court, but the EFTA Court has no power to rule on validity of the acts incorporated into the EEA agreement. So unlike the Court of Justice, it can incorporate the competence of interpret the competence of the Joint Committee and all that, but it can never say that a particular act incorporated into the agreement is invalid. How is the court organized? There is a there are 3 judges at the EFTA Court, one nominated by each state, and then they are appointed by a common accord by the EFTA states. The court always sits as full courts. All its rulings are issued by the entire court. The president may issue certain procedural decisions, but all rulings, then I mean advisory opinion, judgment, orders, decisions, whatever you call it, they are from the entire court. The court is organized with a cabinet structure, so each judge has his cabinet with personal assistant and legal secretaries. Then there is the registry, which I had, which is dealing with certain procedural issues, and the court's administration. The court is a rather small institution, if comparatively speaking, for an international court with 20 people. It has a very simple language regime, so the working language is English, and it's only in the advisory opinion that the request for an advisory opinion is received by the EFTA Court in the language of the referring court, so Norwegian, Icelandic or German, and it is issued, the judgment is authentic both in English and in the language of the referring court. But all the procedure essentially takes place in English, so which makes for, it certainly is an easier task administratively than having 24 languages and the translation and interpretation work that comes from having that. The average duration of proceedings is from 8 to 12 months. I think that sort of would go for most typical advisory opinion requests and direct action. Of course, if it's a very, in particular, voluminous direct action, it will take longer because the written procedure is much longer and has more stages than in the advisory opinions. Then we come to the types of cases. And essentially there are 2 types of cases that the EFTA Court hears. There are so-called direct actions and advisory opinion, both of which have been touched upon here before. And if we start with the direct actions, then also the road forks there into infringement action or infringement proceedings and action for annulment or challenges against ESA. So if we take first the infringement proceedings, that's so-called Article 31 of the Surveillance and Court Agreement, and actually also, if you want to be very precise, Article 32 of the agreement foresees the possibility of an EFTA state suing another EFTA state in front of the EFTA Court. That has never happened in the close to 30 years of the agreement's existence and is, pretty unlikely ever to take place. But Article 31 is, of course, is responsible for many of the cases, and I'll get back to that in a little while. Then we have the challenges against ESA, and there practically we're looking at the so-called actions for annulment under Article 36, although there is also, and there have been a handful of cases on either so-called failure to act or the liability of ESA, but in practical terms these articles play a very marginal role in the court's case law. The parties to these cases are then ESA, either as a plaintiff bringing the case or the defendant, and then mostly it's of course the EFTA states in the infringement proceedings as defendant, and private entities can bring actions against ESA and do sometimes in the field of state aid. If we look at this a little bit more closely, then the Surveillance and Court Agreement is, as you probably will have gathered from the proceedings here today, is an instrument by only the EFTA states, which sort of is foreseen by the EEA Agreement, but is only an agreement between the 3 EFTA states. But of course, many of its provisions are modeled on EU law. So Article 31 about the legal basis for the infringement procedure is modeled on what is now Article 258 of the Treaty on the Functioning of the EU, and which has been in place ever since the beginning. And essentially the infringement procedure as a matter of EEA compared to EEA law is the same, except that the EFTA Court has no competence, as the Court of Justice has under Article 260, to issue fines or periodic penalties either for late implementation or failure to comply with earlier judgment. That sort of is the main difference. Otherwise, the infringement proceedings follow very much the same rules as in the EU pillar. In the court's case law, there have been quite a lot of cases under Article 31, but mostly they have been about failure to implement regulations and directives. You saw the so-called scoreboard earlier today, and there's a list of the regulations and directives which haven't been implemented, and most cases brought under this route have concerned a failure to implement in time one of these regulations or directives incorporated into the agreement. The Article 36 also has its EU treaty counterpart, Article 263, which of course a lot of ink has been spilled over the decades on discussing standing of private applicants and issues linked to that. That plays a relatively limited role in the EFTA Court's case law. These cases are by and large all about state aid, although of course you heard about the Telenor case on competition. That's the second competition case the EFTA Court has heard as by way of direct action, and there have also been a few cases on access to documents. Leaving that aside, these cases are all about state aid. And typically then either a competitor that is unhappy with ESA not doing any further work on that state aid case, which then sues, or a recipient of the aid and the EFTA states not being all too happy about having to repay unlawful and incompatible aid back to the state. Those are sort of essentially the two types of state aid cases heard. Then we come to the advisory opinions, and similarly as is the case with the Court of Justice and its preliminary rulings, most significant cases in the EFTA Court canon stem from requests for advisory opinion. So the establishment of state liability and important principles of EEA, they have their origin in request for an advisory opinion. So a few basic issues. Who can request an advisory opinion? That is any court or tribunal in an EFTA state. So the English uses court or tribunal. It's important to highlight that this is not limited to courts within a narrow meaning. It can be also administrative bodies that fulfill certain independence requirement that can and have indeed on many occasions submitted such request. When to request it, that's essentially up to the national court when it feels it's in a position that the advisory opinion is necessary to render judgment in the main proceedings. But there is no, whether it's done at the first instance or while it's still pending at an administrative tribunal or at the final instance, there's no requirement to that effect. Then there's a question, this is an advisory opinion, and I will return to that, not a preliminary ruling. So I have here always followed within speech marks. Maybe that brings me to the next slide. So, yeah, then again, we have an article based on the EU model, the preliminary ruling procedure. However, that was one of the key elements of the EEA negotiations, that these are advisory opinions, they're not binding judgments like the preliminary rulings. And that, of course, the $64,000 question is, does that really matter? For the most part, I think it's safe to say it doesn't matter. And the compliance rate is very high, but of course, now with almost 30 years of existence of the EEA agreement, obviously there will be a few hard cases which have sort of brought this tension to the forefront. And yeah, I'm obviously not going to go into these two cases in any detail. That would take up way more time than we have here today. But here, if someone is interested, I have highlighted here two cases. One on the interpretation of the Posting of Workers Directive, where the Norwegian Supreme Court took a different turn than the EFTA Court, and then Fosen-Linjen, a case which came twice to the EFTA Court, once following a request for an advisory opinion from the Frostating Court of Appeal, to which the EFTA Court responded. The Court of Appeal disagreed with the EFTA Court. That case, the Supreme Court granted leave to appeal and then referred it itself to the EFTA Court, which then gave a second ruling, and that second ruling was then followed by the Supreme Court. So all's well that ends well, but I think these cases, would merit a longer discussion, but I'm putting them here more to highlight that, yes, there are isolated instances which are interesting to discuss and debate, but overall the fact that these are advisory opinion, not preliminary rulings, is of very limited significance. And I've also here put that there is no explicit duty on courts of last instance to refer, like in the ECJ, which the EFTA Court commented on in the so-called Irish Bank case, where it says that, yes, there are differences, there is no similar duty, but the EFTA Court, I would like to interpret this as an encouragement and a reminder of the loyalty obligation and that they should refer. And indeed, if you look at the last years, there have been several such references. I don't know, I assume the NAV saga has been mentioned here today, and there indeed the Norwegian Supreme Court referred the central case, sort of dealing with the compatibility with EEA law of that saga. That was referred to the EFTA Court, and 16 questions referred, and that was followed in a judgment that came out just before the summer. So I wanted to mention very briefly here what I've labeled as milestones, and here I've put what I think is the most important case in the history of the EFTA Court, Erla Maria Sveinbjörnsdóttir, which established on slightly different terms than the Frankovich liability in the EU state liability for the EEA. And I've put here what I think is sort of the most important paragraph, where the EFTA Court is expressing itself on the nature of the EEA. And you see this is slightly more elegantly phrased than my international treaty with a twist, sui generis, which is use of Latin when you're not really sure how best to say it, and then it's easier. It at least always sounds good to use Latin. So but here are a few. So it's not a customs union, an enhanced free trade area, which is something more than just a regular free trade area. It's not quite a treaty, but something more. So you're sort of mirroring what I was saying there at the very beginning. We are here at a particular intersection between public international law and EU law, closer to EU law, but not quite there. But state liability there is, and this is late. This is rendered in December 1998, and a few years later in Osbelt, the other sort of central judgment for the understanding of EEA law here from the point of view of the Court of Justice is Osbelt, a case concerning real estate transactions by Liechtenstein nationals in Austria who were relying on Article 40, the free movement of capital, and there essentially, as I like to say, the Court of Justice confirmed that the EEA agreement had succeeded in extending the internal market to the EFTA states. So, and that's what the words I have highlighted here, that there is an extension. Melpo mentioned the case of the Icelandic national on vacation in Croatia, wanted by the Russian secret police. That in that judgment, this paragraph is confirmed, and that also shows and they are essentially on the basis of the freedom to provide services, an EFTA national received the same protection as an EU national would receive on the basis of the treaty provisions on citizenship. I've only, given that there is slightly less time than sometimes, I've only added one more slide in these milestones. So, and that again is because we're sort of discussing the EFTA pillar. This is the so-called iSave case. Now, time flies. I feel that in my mind, the financial crisis wasn't that long ago, but I understand then if I look across the hall, many of you won't remember that in the same detail as, those who lived through it and have reached a certain age. So, this was a case resulting from that Landsbanki, one of the failed Icelandic banks, raised a lot of money in the UK, offering unsustainable interest rates. This all turned sour would be a polite way of phrasing it. And the issue was, what were Iceland's obligation vis-à-vis the depositors of these branches of Landsbanki in the UK and the Netherlands. ESA brought the case to the EFTA Court, which acquitted Iceland and dismissed the application. This judgment is long and detailed and warrants reading, and I've here just in very brief terms said why the EFTA Court found in favor of Iceland as a defendant, saying Iceland was under an obligation to establish a scheme, not guarantee payment in all cases. The directive is to cater for individual financial institutions going bankrupt, not the crash of an entire country, essentially. 93% of the banking system in Iceland collapsed in 4 days. And the recital suggested that the burden on the state shouldn't be too onerous, which also had some support in the legislative history. Obviously, a case of this magnitude and legislation of this complexity, this is an issue that may legitimately be debated, but I think I put it up here to highlight this as certainly the most significant case ESA has ever brought, and the fact that this was, even if 2 EU member states were involved, this was the end of the story. So the ruling of the EFTA Court was accepted by the Union, and that says that is in a way, in my mind, a success story for the 2-pillar structure. The ruling of the EFTA Court was accepted as the sort of final step in this. Interpretation of EEA law. Here I have simplified somewhat Article 6 of the EEA Agreement and Article 3 of the Surveillance and Court Agreement about the obligation on the EFTA Court and the courts in the EFTA states to interpret EEA law in conformity with the case law of the Court of Justice. This is again all about homogeneity, same rules, and so forth. And here there is really a key issue. If you're looking at the case law of the EFTA Court, it's the what I have termed here as a rebuttable presumption. If you have the same provision in place in EU law and EEA law, the working assumption should be the same interpretation applies, and something very specific and special is present. I've listed 3 cases where there is a deliberate deviation based on the specific EEA context. Of course, if you look for cases where the EFTA Court has ruled differently than the Court of Justice, you might find that and might think the EFTA Court got it wrong, but that's a completely different element. Here I'm looking at issues where the EFTA Court says, we are aware of that, the Court of Justice says A, but we are in the context of the EEA Agreement, so we say B. I'll get to this in a little more detail if Þorfinnur doesn't stop me. So here, just sort of the establishment of this presumption took place, as you see, quite early on. This is really where the court established its standard approach to this in 1998, and I've highlighted how, without any such specific circumstances being present, homogeneity should prevail. This was a residence requirement in Liechtenstein for, I think, board members or managers, can't remember. This was restriction on the right of establishment. Liechtenstein said, but this is justified on the basis of public policy, which is a much broader and wider concept in the EEA than in the EU, because there is less integration, so on and so forth. And that was given very short shrift by the EFTA Court. And the Court of Justice, although the language used hasn't been exactly the same, has on many occasions endorsed the same approach. And here I picked one random case where they've said the same, where it essentially says both we and the EFTA Court have recognized you need to reach the same result and apply the same interpretative methods. One issue which wasn't really thought of when the agreement was entered into is what happens if the EFTA Court let me just step back. Of course, the EFTA Court is dealing with issues where there is often no clear answer in the case law of the Court of Justice, so the EFTA Court using input from those participating in its proceedings and the same methods and canons of interpretation as the Court of Justice endeavors to reach the same result. That, I'm confident to say, is a success almost all the time, but not quite maybe. And then if the EFTA Court has said something, and then the Court of Justice comes later and says, we look at this piece of directive a little bit differently, what's the prevailing view? I'm not going to read this quote, but essentially in L'Oréal, which was about whether the trademark directives provide for an EEA-wide or an international exhaustion of trademarks. The EFTA Court said international. The Court of Justice said EEA-wide. The EFTA Court got a question 10 years or so later. What do you think? And the EFTA Court said, well, we adjust our case law. And that's the quote I put here. But I think it's important that the EFTA Court, I think the EFTA Court would have stood its ground if it had found that the reasoning in Maglite was more convincing, but the point is that the EFTA Court will examine, as always, are there any reasons as a matter of EEA law for deviating, and if there isn't, homogeneity trumps any other considerations. There are some who says this is the EFTA Court just, diminishing its own stature. I think that's a misunderstanding, because there cannot be more value in, the going first doesn't trump homogeneity unless you have something else and more than just having been there first and having to eat humble pie. So, and also, I want to say that this is further explained by the family reunification cases on the Citizenship Directive, where the EFTA Court was dealing with a difficult situation that the Citizenship Directive is in the EEA Agreement without any adaptation, but the citizenship provisions are missing. So essentially the meat without the bones, and that of course was bound to be tricky for the court and anyone else dealing with this. So the court was faced with the issue what to do with returning nationals, which in the EU pillar could base their rights on Article 21 of the treaty, but which had no direct counterpart in the EEA. The EFTA Court held that the Article 7 of the directive applied and gave the returning nationals and their spouse rights in Yabi, and then the Norwegian Supreme Court asked again in Campbell, and then and pointed to several judgments where the Court of Justice interpret differently, but there, unlike in Maglite, the EFTA Court said, hold on, here the context is different in the EEA, that hasn't changed, so we believe that the principle of effectiveness mandates that we give it a different interpretation in the EEA. So I think I'll just say that the EFTA Court is frequently cited by the EU courts, and I very much like this comment of Advocate General Trestenjak. Then I think Torfinnur is standing up, so I think I'm have exceeded my time, or at least am about to. So I think I'll just stop with that, and I'm happy to take any questions.
Yes, thank you, Ólafur. And actually, there's a question in the chat from some online viewer. I don't know if you like the whole wording of it, but he's referring to the Japi and the Sveinbjörnsdóttir cases, where it is stated here that it is in conflict with the intentions of the contracting parties. And so the question is, do the EFTA states have infinite patience for the EFTA Court's judicial activism?
I would of course start by saying I regard neither of these, especially not Yapi, as a point of judicial activism, at least not in the negative sense. If the listener would or viewer would read Sveinbjörnsdóttir, I think that establishes liability with different grounds than you see in EU law, but I would submit equally compelling, and I think that is a question that was deliberately left unanswered by the contracting parties. So if they had wanted it answered in either in the affirmative or in the negative, they should have dealt with it. And as I say, Yapi, I would think that if the intention of the contracting parties is little to go by if the contracting parties themselves disagree. So if you have an EFTA state saying A and the commissioners representing the other contracting party saying B, then I think the EFTA Court has very little to guide itself by if the will of the contracting parties is what you should be guided by.
Fair enough. Questions from the floor? Yeah, there are a couple of questions. So we have to give this another 5 minutes.
Thank you. I'm Perrine. I'm the city legal trainee. I had a question. In the previous presentation, it was mentioned that ESA can intervene in front of the ECJ. Mm-hmm. So I was wondering if there's a mirroring approach in front of the EFTA Court. Can the European Commission intervene in the cases?
Yes. I mean, that has been the... But I think we need to also... The word intervene has been used a little loosely. In all cases in front of the EFTA Court, except these sort of what I call rubber stamps, where it's just Iceland didn't implement directive on something by date so and so. In all other cases, the Commission submits written and oral observations in the EFTA Court, and in a handful, at least in one infringement case, it has actually intervened, and the point of intervening is saying then it supports the action of the EFTA Surveillance Authority. And the EFTA Court is more liberal in the Court of Justice in the say in direct action. You can also submit written observations without having to take a stand either with the plaintiff or the defendant. What happened with this recent order of the President of the Court of Justice is that both ESA and the EFTA states may intervene in this sort of formal sense of intervention in infringement proceedings.
Another question here.
Thank you, and thank you for an interesting presentation. I'm Julia Snelligan. I'm a trainee at the Confederation of Norwegian Enterprise. And I have a question regarding to what you told about the advisory opinions. As you mentioned, this is like an option, a right for the EFTA member states. It's not a requirement. It's not something they have to do. And I was wondering if you could elaborate a bit on the relationship between the EFTA Court and the EFTA member states in regards to making use of this right, and also for you, I guess, the EFTA Court, is how you make sure you stay relevant. And
Yeah. I mean,
yeah.
How much time do I have, Thorfinnur? That maybe this was, given Thorfinnur's expression, this was not the question I should have received. I would say that the advisory opinion currently is, especially if you from the point of view of Norway, is working really well. We have had in the last 3 years, I think, 5 requests from the Norwegian Supreme Court, 3 of whom in very substantial cases. The caseload of the last 3 years has been driven almost exclusively by advisory opinions. I want to in particular mention that Liechtenstein has always been an excellent pupil, following the Austrian example, and of submitting. Liechtenstein has submitted as many requests for advisory opinion as Iceland. So, and the Norwegian experience in the last, let's say 5 years is extremely positive.
Okay, very good. Thank you so much, Ólafur.
Thank you.